Welcome to the Wills and Estate Transmission Podcast, brought to you by De Groots, specialist lawyers in wills and estates.
Hi, and welcome to the podcast channel with degroots.com.au. And we've got a little bit of a different podcast today. We've had quite a few questions from listeners, and Maree Harris is here to help us answer some of those questions. Hi, Maree.
Hi, Tony. It's great to be here today.
Excellent. So a lot of it is to do with contesting a will and so on. So I just want to ask you the questions as we go along. Sure. And we're relying more along New South Wales because that's where you're based. But most rules are similar, and I'm saying the word similar.
That's right. Yes, there are differences between different jurisdictions. So it's very much dependent on which state the deceased lived in.
Yeah. Okay, so I wouldn't worry about it too much for the listeners because generally they're similar. There's nothing majorly different between the different states, is there?
It sort of depends on... there are some intricacies, and it depends on the legislation in the different states. You know, sometimes eligibility might be different in different states. But they are similar. Yep. That's why it's good to talk with a lawyer, and they can explain the differences depending on the state the deceased was domiciled in.
Absolutely, that's right. Okay, cool. All right. There we go. Okay, cool. So my internal light here just turned off. You know, those lights that if you don't move, they turn off. Lots of fun. Cool. All right. So let's get going. So I'm going to ask you the first question. So what does it mean to contest a will in New South Wales?
So what I'm talking about when somebody says contesting a will in New South Wales, really you're saying that the last will is valid, but the applicant has not been adequately provided for their proper maintenance, education or advancement in life. So you're not challenging the validity of the will, you're just basically saying that applicant hasn't received provision and they want to make an application for provision or further provision from the deceased estate.
Right, so who in fact is entitled to contest a will?
Yes, so there's a list of eligible persons which are set out in Section 57 of the Succession Act, Tony, and that legislation really sets out who is eligible to contest a will in New South Wales. The people that you're looking at would be the spouse or partner of the deceased person, a child of the deceased person, a person who was living in a de facto relationship with the deceased at the time of death. A former spouse of the deceased person is also relevant, and a grandchild could be an eligible person as well, but they need to prove that they had been dependent on the deceased at a particular point in time, so they're not automatically eligible. They've got to have factors warranting the making of their application, and also a person who was living in a close personal relationship with the deceased at the time of death. And another eligible person would be a person who lived with the deceased at a particular point in time and was dependent on the deceased. So, for instance, a stepchild might be considered under that category, but a stepchild in New South Wales is not eligible of their own right. They need to have proved that they lived with the deceased at a particular point in time and were dependent on them.
Yeah, I think that's the key word, isn't it? Dependent and financial dependency.
Correct. Yes, that's right, Tony.
Great, okay. So how does contesting a will differ from challenging a will?
So they're different grounds, really. So as I mentioned earlier, contesting a will is really accepting the validity of that last will and basically making an application for further provision or for provision from the deceased person's estate. Whereas challenging a will, that's often referred to as challenging the validity of the will. So, for example, if the deceased didn't know and approve of the contents of the will, you might want to try to challenge that last will. Or if the deceased didn't have capacity to make that will, you'd be challenging the will as opposed to contesting the will. And with respect to challenging a will, if you were successful in overturning that last will, then that would be struck out, and then you would turn to the penultimate will of the deceased, or if they didn't have a penultimate will, then the estate would be distributed according to the laws of intestacy. So they're really different causes of action. One is about attacking the validity of the will, and the other one is accepting that the will is valid, but basically saying the applicant wasn't adequately provided for in that will.
Right, so what actually is the role of the Supreme Court in these cases?
So the Supreme Court is basically the court where all applications are filed. So if you are challenging the validity of the will, or if you are contesting a will, you would commence proceedings in the Supreme Court of New South Wales.
Right, okay. So what are the typical steps involved in contesting a will?
Sure. So normally what would happen would be an applicant would file a summons and a supporting affidavit in the Supreme Court of New South Wales. Once that is done, then you would get a date for a directions hearing, and a directions hearing is really just about case managing the matter. So the client wouldn't need to turn up at the directions hearing, the lawyer would turn up on that day, and the registrar would really just set a timetable for the matter, and that includes dates for the filing and service of evidence. So you would file and serve affidavits, and then you might have more affidavits in reply, and then you would usually get a date for a mediation.
Right, so there's been some pretty big contesting or fighting of wills recently, especially one in Western Australia. So that's how messy it can get. So
Yes.
what's some of the steps on those that make it a bit more interesting?
So it depends on potentially the size of the estate. That can make it a bit more interesting. It depends on who is making the claim. So, for instance, is it stepchildren versus their stepmother? That can make it a bit more interesting. There's a number of intricate matters that would come into it, and really is a fact-specific thing, Tony. So you're looking at the circumstances of that particular case itself. So who is your applicant? What are they fighting over? What provision has been made for them in the will? What provision has been made for them by the deceased during the deceased lifetime? Those are some of the considerations. Estrangement is another issue that's been coming up lately. So whether or not, let's say it's a child and they've not received provision from their parents' estate, whether they've been estranged and whether there was any sort of reconciliation, that might be another issue that comes up, which would make the case a bit more interesting.
Right, so I just thought of something. So do parents have to provide for their children?
So, at De Groots, we often tell our clients, you should do what you want in your will. If you want to provide for your child, you provide for them and do what you want to do. It's an interesting question because, there's nothing in the legislation that says that you have to provide for your child. However, if there's money in an estate that is left and your child, has a need for further provision from an estate, then a court may make an order ordering that your estate provide for that child if you've left them out of your will. So really the question is, who do you have a moral obligation to provide for? And based on community standards, have you provided for that child or not? And there could be a potential contest if you've not provided for that child, because that child would be eligible to make a claim on your estate. But the other question is, who are the other people that you've got a moral obligation to provide for? So, for instance, if you've got a spouse, well, you've got a higher obligation to provide for your spouse rather than to your children. So these are some of the things that the court would look at in determining whether or not to make further provision for that child.
So can you write the children out specifically?
Look, you can. And again, your estate may be faced with a will contest down the track once you have passed away. There might be reasons for why you've not made provision for your children and they might come into it, but ultimately it would be a matter for the child to then make an application for provision or further provision in the future once you've passed away. And then if you can resolve the proceedings at mediation, well, that would be the end of it there. If not, it would proceed to a court hearing and a judge would determine whether or not adequate provision has been made for that child and whether further provision should be made, and if so, the amount of provision that should be given to that child.
Right. So what are the typical steps involved in contesting a will?
So what you would need to do would be, I would recommend that you go and see a lawyer first of all, because there is a time limit for contesting a will. You've got 12 months from the date of death in order to contest the will. So it's important that you get advice as early as possible from a lawyer as to what the process is and what your rights are. Normally what you would do, you might try and negotiate with the other side, but if you can't negotiate, what you would do is you would start preparing your court documents and you would commence proceedings in the Supreme Court of New South Wales. And normally the matter would be referred to a mediation, which is a form of alternate dispute resolution. Mediation is compulsory in this area, so before you would get a date for a hearing, the matter would be referred to mediation. And to be honest with you, Tony, most of these matters do settle at mediation. I would say at least 90% of matters settle at mediation and don't actually proceed to a court hearing. So you would likely or hopefully be able to settle your matter at mediation if you do bring an application for provision or contest the will. But ultimately it depends on all the parties at the mediation and whether they're prepared to compromise on their position and to try to resolve the matter.
Yeah, so, and here we go for this one. So what kind of evidence is usually required to support a claim?
So normally you would file your summons, which is your originating process. Attached to that would be an affidavit, which would set out your applicant's case. So the types of things you would be putting in would be details of the relationship between the applicant and the deceased person. Basically, you would have to set out the applicant's resources, so you would be setting out details of their assets and liabilities, their income. You would be setting out details of their partner's assets and liabilities and income. You would be setting out details of their health circumstances, any provision that the deceased has made for them during the deceased's lifetime would need to be set out as well. And you would also, what a key piece of evidence is what needs that person has for further provision or for provision out of the estate. So for instance, do they own a home? Do they have a mortgage? That goes towards their needs. So that all needs to be set out in the form of an affidavit. You also need to file what's called a notice of eligible persons, which sets out other people who are eligible to contest or to make a claim on the deceased estate. That needs to be provided. And you would need to provide a cost affidavit, which would set out what your estimated costs are to a mediation. So all that needs to be filed and provided to the other side. So you really need to be upfront about your financial circumstances, because that's a key aspect of your claim and why you have not been adequately provided for in the deceased will.
So here's a fun one. So how long does it take to resolve a contested estate?
Yes, so normally I tell my clients that from the time they commence proceedings, it's a couple of months before they get a mediation. Before you get a court hearing, though, you're looking at approximately a year from the time you commence court proceedings. So it can be quite a long time before the matter is actually finalised. And it can be quite stressful for clients to go through that process. It can be emotionally draining to go to a court hearing. I can tell you it's not fun to be cross-examined by a barrister who is acting for the other side, and people often don't like the stress of a court hearing and want to try to resolve a matter, and that's why mediation is so important, because It gives the parties certainty. If you do mediate on the dispute, you can document the agreement, and all the parties would sign that document. So you would have the certainty of knowing what the outcome is. The parties actually have some of the control because they are able to decide themselves on the outcome as opposed to leaving the decision to a judge. And you can just put the matter behind you and put the stress of a hearing behind you. You don't have to go through all of that. So mediation is quite good in terms of trying to bring all the parties together to try to resolve the matter.
So what does mediation typically look like?
So normally in these matters you would get a court-annexed mediation, which would be a mediation that's run at the Supreme Court of New South Wales. Parties can request a private mediation if they want to, but that is more expensive, whereas a court-annexed mediation is free. Normally how it would run would be all the parties would start off in one room together, Tony, and the mediator would address everybody. And then the plaintiff or the applicant's barrister would stand up and say something about the plaintiff's case and why they haven't been adequately provided for in the last will. And then the defendant's barrister would say something about the defendant's case and why further provision should not be made for the applicant. And then the parties would separate into separate rooms. That's when the real negotiation begins. So then you're in separate rooms for the rest of the mediation, and you start making offers. So it's customary for the applicant to make the first offer. So they would make the first offer to the other side, and then the other side has the choice to either accept that offer or to reject the offer and make a counter offer. And it goes backwards and forwards until hopefully the parties reach an agreement, which can then be documented and signed by all the parties. And either, if it's a court-annexed mediation, the registrar could potentially make the orders then and there, which would be the end of the matter. Or if it's a private mediation or the registrar doesn't have the power to make the orders would be sent up to the court for consideration, and then they could be made by either a registrar or by a judge.
Right, so it's not like what you see on TV where people do sneaky things and they start yelling and doing all sorts of stuff.
Well, sometimes that can happen, and sometimes you might need to restrain your client, and you will often see security up at the court and they're ready there to escort people out if need be. Sometimes it can get quite heated because it's quite personal for our clients and emotions are running high. And, for them, they've been living and breathing this case. It's all they've been thinking about. So it can get quite heated. I don't often recommend that my clients say anything during the mediation. Although it is their day, that's why they've employed me and a barrister as their advocates. So really it's our job to advocate for our client's case. So I don't recommend that clients say anything because sometimes that can just provoke the other side and it's not conducive to resolving the matter. But ultimately it's up to the client. If they want to say something, they can. And sometimes I have seen people lunging over the table and going for the other side, and it's not great, but it does sometimes happen. It's not common, but it does occasionally happen. So, as I said, you do have security up at the court who's there, or the mediator's there, and really the mediator's role is to sort of play an umpire in these sorts of matters. The mediator just facilitates the process. They don't actually have any control to make the orders.
And how are mediators selected?
So if it's a court-annexed mediation, the mediator would be a registrar of the Supreme Court. So the parties have no say as to how that mediator is selected. However, if it's a private mediation, then the parties have a choice as to who they appoint as a mediator. So you might have ex-judges who might be mediators, or you might have some barristers who just run mediations, or there are just some people who are trained as mediators who can run the matter. And you would often take into account the size of the estate and who's paying for the mediation, and that would come into the type of mediator that you're going to select. Some some mediators are more expensive than other mediators. So you would need to take that into account in determining which mediator to select if it was a private mediation.
Right, so what advice would you give somebody who's thinking about contesting a will?
So the biggest piece of advice I would give to somebody is to go and see a lawyer as soon as possible. Don't leave it too late, because you don't want to wait 12 months or after the 12 months from the date of death and you've missed your boat and you can't contest the will. I mean, you can bring late applications, but the other side needs to consent to a late application, or you need to get leave of the court. So you really don't want to be in that situation where you need to seek permission. I would say speak to a lawyer, get advice about your rights and entitlements as early as possible, and then you've got time to decide whether or not you actually want to pursue the claim or if you just want to let things go. But it's important to speak to a solicitor, somebody who practices in wills and estates and who knows this area of law, so they can give you the right advice. I'd say that's the biggest piece of advice that I'd give to a client, Tony.
So it's probably wise to, think about it and then go, okay, within the first few months, look, I'll get some advice anyway, and that gives me the option, and I don't have to continue at all.
Correct. At least then you've got peace of mind, you've pursued it, you've got some advice about your rights and entitlements, and then you can, either go ahead and make a claim, or you can say, you know what, I don't want to go through the stress of it all, that I'm just going to let it go. But at least you've investigated what's open to you. And also, I would say do it sooner rather than later, because you don't want to be in a situation where an estate has been distributed and then you want to try and contest the will, and it's just so much harder to try and claw back the monies that have been distributed. So the sooner you get advice about your rights and entitlements, the better for you. There's no point in waiting. At least once you've received that advice, then you can decide what you want to do.
Right, okay. Look, thanks very much, Maree. So can you just give us a quick recap, please?
So just a recap, so when we're talking about contesting a will in New South Wales, we're talking about a family provision application. So making an application to the Supreme Court of New South Wales for provision or further provision for your proper maintenance, education or advancement in life. The limitation period is you've got 12 months from the date of death in order to make that application. So just be mindful of that and don't let it go for too long before you seek advice about your rights and entitlements in an estate. There are eligible people and they're set out in the legislation, so talk to a lawyer about whether or not you're eligible to contest a will. And just remember that most of these matters do settle at mediation, so even if you commence court proceedings, about 90% of the matters actually settle at mediation, so it's likely that your matter will fall into that category as well.
Great, thank you very much, Maree. Is there anything else you'd like to add?
No, that's all, Tony. It's been a pleasure chatting with you today, and yes, I hope it's been useful for all our listeners out there.
Great, thank you very much.
Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website www.degroots.com.au and book